Thank you, my Lord. Before the break, I was submitting to your Lordships that it's important to have in mind clearly the change in legal status of the December redeemers, which took place on the 1st of December from shareholders to creditors.
Right.
It's also important to have in mind that that, of course, had an important economic as well as legal consequence. At that point, they ceased to be participants in the capital of the company, sharing in its fortunes and its profits and losses on an ongoing basis. Instead, they became creditors with an entitlement to a fixed and liquidated sum against the company in accordance with the article. So at that point, they'd effectively exited from the capital structure. They were no longer exposed to the profits or indeed the losses of the company continuing from that point on. Now, my Lords, against that context, we do submit it's important to appreciate what the appellant's case before your Lordship in fact involves. He says that notwithstanding the December redeemers were creditors at the commencement of the winding up, they should nevertheless rank in the liquidation as if they were still shareholders in respect of the relevant shares. And in order to achieve that, it said that the court is able and is required to reinstate those shares back to the December redeemers. Now, this is not a point that was really touched on during my learned friend's submissions, but it is helpful to look at the relief he's actually seeking from your Lordships as set out in the appellant's written case.
Does he need to say that? He's ultimately saying that the concept of redeemed in 7A, 37.7a, means the whole process of redemption, including payment, has been completed. That's all he's saying. He's giving it that meaning in 37.7a, possibly throughout 37.
Yes.
Non-constat that they're treated as still having shares. I see how you say...
No, I think the reason for doing it is that it's a bit odd to treat somebody who isn't a shareholder as if he was, and it becomes less odd if you make him one.
That's right.
Well, I understand that.
I mean, as a forensic
well, absolutely.
device.
And the other reason is there's no other provision in the Companies Act that says we would rank as a shareholder. I mean, he can't point to a provision in the Act that would subordinate our claim to rank.
No, he's relying on 37.7a. All he's saying is, on one view, whether the shares have been redeemed and so on, in the sense you're using it, what it's saying is that where the whole redemption process hasn't been completed, as money isn't paid, the money falls within 37.7a.
But you have to understand his case is that 37.7a doesn't apply to us because he says we're in it.
He says nothing's payable under 37.
Yes. I mean, he says we're in it.
And therefore, I mean, your point is that there's, under what is anything payable, since the articles mean something?
Exactly. And his case, in order for it to work, he needs the relief which he seeks from your Lordship at paragraph 182 of his written case, core bundle tab 8, page 905.
So his printed case paragraph?
It's paragraph 182, and then subparagraph B, numeral 3.
Page 60.
Internal page 61, page 905. And you'll see the relief which he seeks is essentially that the registered members be rectified and the shares be reinstated back to the December redeemers. And he needs that, because otherwise there's no basis for saying that we should rank in the liquidation as if we were shareholders. So in effect, what it's said the court should and is indeed required to do is to unwind the redemption process which took place under the articles in December 2008, to undo the reduction in the company's share capital which took place, to reissue the cancelled shares back to the December redeemers, to amend the register of members to reinstate the December redeemers as shareholders, and as part of that, presumably to cancel the claims of the December redeemers as creditors.
it's logically, if that is relief he'd be entitled to in this case, he would equally be entitled to it if the company had not become insolvent, but they had simply decided that they'd rather not pay.
Yes. Yes. And well, the short answer we say is there's simply no power under the Companies Act or given to any court to carry out those sort of steps. Someone who is a creditor at the commencement of the winding up ranks for payment as a creditor. Under the express terms of the company's law, he's required to be paid before the shareholders can receive any return of capital. And there is no power or ability to cancel that person's creditor claim, to reconvert that person back to a shareholder, so that that person then ranks alongside the remaining shareholders to a return of capital. And well, we're not aware of any case in any jurisdiction since the enactment of the Companies Act in England in 1862 in which this has been done. In other words, where you have someone who has been validly redeemed under the articles and become a creditor and who is sought to be reconverted back to a shareholder. Now, the other point we just emphasise at the outset is that the appellant's case in our submission is at odds with the nature and purpose of the redemption process. The whole purpose we submit of a shareholder ceasing to be a shareholder is that he will cease to be a participant in the risk capital of the company, sharing in its profits and losses going forward. And as I submitted a moment ago, at the point he ceases to be a shareholder, he's effectively replacing that exposure with an entitlement to a fixed sum as a creditor calculated in accordance with the articles. Now, there's no sensible reason we suggest why the company should be able to reverse that process simply because its fortunes decline after the person has ceased to be a shareholder, but before the payment of the amount due on redemption has been made. And an even less good reason why the company should be able to do that simply because it has itself defaulted on its own payment obligation to pay the redemption amount to the shareholder. And in effect, what the appellant's case involves is saying that a shareholder who has ceased to be a shareholder, who has exited the capital of the company, will, notwithstanding what the articles say, remain exposed to the company's fortunes and remain at risk of having the subsequent losses of the company upon him, for so long as the company itself fails to make payment of the redemption. And in our submission, there's no reason at all why that should be the position. And the other point is that the appellant's case on this is in effect a one-way bet for the company. No one is suggesting if the position had been the other way round and following the 1st of December 2008 and the company had discovered a gold mine in Peru, to take an unlikely example, and its value had increased hugely, that the December redeemers would have been able to have undone their redemption and get their shares back to capture that increased value. I mean, quite plainly, if they'd sought to do that, the first thing the company would have said, well, no, it's too late. You got out. You replaced your exposure to the company's risk capital with a claim to a fixed sum, and you can't now reverse it. So the liquidator's case is in effect a one-way bet for the company. It's saying, well, you may have got out, but if things go very badly for us,
Yes.
and we go into liquidation, then we can pull you back in. And there's no good reason, as a matter of policy or under any of the provisions of the company's law, why that should be the position. And, my lord, our case is essentially very straightforward, I hope. I mean, we simply say the December redeemers were creditors, unarguably, at the start of the liquidation. Company law requires all liabilities to be paid in full before members are entitled to any return of capital. And therefore, we rank ahead of and not alongside the rights of members to a return of capital. And that's the basic position in our submission. Now, I was going to deal next with the statutory scheme in winding up. We've dealt with this in a little detail in our written case, section D. But for present purposes, there are two features I'd like to emphasise, if I may. The first is what we've called the principle of creditors first, members last, which is what is in our submission a general principle of insolvency law, that where a company is in liquidation, all of its liabilities have to be paid before shareholders are entitled to any return of capital. And in the case of the Cayman Islands, this principle is embodied in section 141 of the Companies Law. If I could take your lordships to that, it's in the second authorities bundle behind tab 43, page 1882. Section 141, subject to subsection 2, which isn't material for present purposes, the property of the company shall be applied in satisfaction of its liabilities pari passu, and subject thereto shall be distributed amongst the members according to their rights and interests in the company. And this is a very long-standing provision of Companies Law, which goes back to section 133 of the 1862 Companies Act. Now, just a couple of points to note. It refers, first of all, to liabilities, not proved debts. So what has to be satisfied are all the liabilities of the company, whether provable or not. And that, indeed, is a point your lordships confirmed in the recent Lehman Brothers decision. And you'll see, in fact, in section 139, they use the term provable debts, and liabilities is being used in contradiction to that. So all the liabilities of the company have to be paid. Now, it's right that the first part of that section can be regarded as a general statement of principle, because there are other provisions of the Companies Act which mean that not all liabilities may be paid pari passu, as we'll come to in a moment. There are provisions for deferred debts, and as your lordship know, provable debts are obviously paid in priority to non-provable debts. But what it does establish in our submission is the general principle that all the liabilities have to be paid before the shareholders get anything. And, my lords, there was a debate in the written cases before your lordship. It was adverted to by my learned friend, Lord Goldsmith, before the break, as to whether claims of redemption creditors, such as the December redeemers, to unpaid redemption amounts are provable debts or not. And your lordships may have seen that debate in the written cases. We say that they are, for reasons which I'll come to. But even if we're wrong about that, it makes absolutely no difference to our argument. And that's because, pursuant to section 140 subsection 1, even if they were non-provable liabilities, they would still have to be paid in full before the shareholders were entitled to any return of capital. And ultimately, our case involves little more than applying the express terms of section 141. We say the unpaid redemption amounts owed to the December redeemers are liabilities of the company, and they have to be paid before shareholders receive any return of capital. So that was the first feature, the creditor's first, members last principle. The second feature of the statutory scheme, to emphasise, concerns so-called deferred debts. This is basically the section 49G territory. It's the category of debts owed by the company which are deferred to the claims of ordinary unsecured creditors, and which principally owe debts owed to existing and former shareholders in their capacities as such. Now, this is dealt with, as your lordships know, by section 49 of the Companies Law, which you'll find behind divider 43 of Authorities Bundle 2, this time 1875. 1876, subsection G.
Yep.
And again, this is a very long-standing provision of company law. Essentially, the same provision was to be found in section 38.7 of the 1862. And your lordships will see that this essentially defers in right of payment any sum due to any member of a company in his character of a member by way of dividends, profits, or otherwise, and it applies, importantly, in a case of competition between himself and any other creditor not being a member of the company. Now, in the Soden case, in the House of Lords, Lord Brown-Wilkinson basically explained that this applies to rights which are founded on the statutory contract of membership constituted by the Articles of Association and the relevant provisions of the Companies Act. So to the extent the creditor's claim was founded on that statutory contract, because, for example, it was a right to an unpaid dividend or a right to an unpaid return of capital, then it would fall within this section. And as I indicated, we accept that it applies to a claim by a former shareholder for an unpaid redemption amount, because that arises under the Articles. And indeed, before the break, I showed your Lordships the provisions of the Articles which we rely on as giving rise to that claim. Now, there's two key points to note. The first is that it's a deferral in payment, but it's only a deferral that's temporary. And in particular, it only applies insofar as the existing or former shareholder is in competition with anyone who isn't a shareholder. So it only applies insofar as is a competition with someone who might be called an outside creditor. So it's a temporary deferral. And once all outside creditors have been paid in full, Section 49G ceases to be engaged, and the shareholder debts then fall to be paid in accordance with Section 141 before the shareholders get any return of capital. So it's a temporary deferral we would submit in right of payment insofar as there are outside creditors.
Well, it's a postponement which may result in nothing being payable.
It may result in nothing being paid, yes. So if one's in the normal liquidation, where there may be a deficiency, so far as ordinary creditors are concerned, it may result in no payment being received at all. It all depends on, obviously, the assets and the extent to which there are outside creditors. Now, the other point that's important about this is that, as I indicated earlier, it applies not only to existing members, but also to past members. Now, that's a slightly counterintuitive conclusion on the face of it, because it expressly refers to any member of a company. And if your Lordships go back a couple of pages to Section 38, you'll see there is in fact a definition of member in the Companies Law, as there always has been in the Companies Act, and it's essentially someone who's on the register. So if one was putting those provisions together and looking at it literally, one would say member means an existing member. But that's not how it's been interpreted by the courts. It's been given a strange interpretation to include a past member. And that basically stems from a case called Consolidated Goldfields, which your Lordships will find in the First Authorities bundle, behind Divider 4. And if your Lordships go to page 1091, and within the decision of Mr. Justice Roxburgh, page 698 of the report, your Lordship will see that in the first full paragraph on that page, he begins construing section 212(1) of the 1948 Companies Act, which is the same as section 49 of the Companies Law, or section 74 of our English Insolvency Act, as it now is. But what he basically does is goes through the different subsections and comes to the conclusion, which your Lordships see towards the bottom of page 699, that member within section 2121G is to be read in what he says is in the unusual sense of including a past member.
Sorry, where does it say that?
It's really the penultimate paragraph on 699. And then really he comes to his conclusion over on page 700. Quite apart from authority, I should reach the conclusion that though the primary meaning of the word member is clearly applicable in powers A and B, it's clearly inapplicable in C and D, and that the unusual meaning is preferred in powers E and F and in subsection 2. Therefore, I should have reached the conclusion that by that line of reasoning, that member in para G includes in an artificial manner past members. So he basically comes to the conclusion that by going through the different provisions of that section, he's driven to construe member in subparagraph G as including a past member. And he says that's construing it in an artificial sense, it's construing it in an unusual sense. But that's the meaning it has to be given in that particular context. And as I say, that was followed by Mr. Justice Slade in a case called Compañía de Electricidad de Buenos Aires.
Where is that?
Which is behind divider 14. Page 170 of the report, between letters B and C. And you'll see between letters A and B, he sets out sub-paragraph G of section 212. The reference in paragraph G to member includes both present and past members of a company C, reconsolidated goldfields. I can also give you the reference to McPherson, which is in the bundle. I don't know if you'd like me to turn it up. It's McPherson, paragraph 12-014.
So which tab?
Behind tab 55 of Authorities Bundle 2. It's page 1941. Third paragraph down, first sentence. The word member in the context of section 74.2f. And that is the equivalent of section 212G and section 49G has been held to include a past member, and footnote 52, you'll see on page 1944, is consolidated goldfields. And
has, however, been considerable difficulty in determining precisely what it is that renders the sum due to any member of his company in his character as a member. Is that relevant? Anyway,
I'm sorry, well, I mean, there has been the sort of difficulty you see in the Soden case, for example, where there was a claim for misrepresentation in relation to a subscription of shares, and the question was, well, does that sort of claim for misrepresentation fall within it or not? But I don't think there's any particular difficulty in our case, because it's quite clear that the claims we're concerned with clearly arise under the statutory contract in our submission.
But is it right that the similar words in section 37.7b1,
yes,
other than due to members and their character as such, you say has a different meaning?
It does, because
you say it does, but that's your submission, but there's no authority on that.
Well, I rely on section 38, because section 38 supplies a definition of the meaning of member. So your default position in the company's law is that member is the defined term, which is someone who's on the register of members. Now, in the context of section 49G, the court has departed from that, because it's basically said...
In the context of winding up, they've departed from it for the reasons given. But is there any reason why one shouldn't depart from it also in the context, in a very similar context of 37.7b1?
Well, because I think the reasoning why the court has departed from that meaning in relation to section 49G is because it was driven there by looking at how the term member had been used in A, B, C, D, E and F of that very
That's how he
section.
reasoned it. It was not how the Court of Appeal had reasoned it in the other case, is it?
Well, I think how he certainly approached it is by construing the terms of the sections. But he did, I think, accept in a number of places that involves construing member in an artificial sense, in an unusual sense, of the words he used. And in my submission, the correct analysis is one starts by using the definition of member in section 38, and then one asks oneself, is there some reason why one's driven from that? In the context of section 49G, there is. Not so. We'd submit in the context of section 37(7)(b). And as I'll submit in a short while, looking at matters that way does give rise to a perfectly sensible and logical outcome in relation to how one treats these different types of creditors in this case. Now, the other issue, which it's worth touching on, is whether a claim, such as a claim by a redemption creditor to an unpaid redemption amount, is provable, notwithstanding it's deferred in right of payment pursuant to section 49G. As I said, this point isn't essential to my argument. I don't need to establish that it's provable, because even if it's non-provable, it's still paid before the shareholders. But we do say, to the extent it matters, that a claim which falls within section 49G is nonetheless provable. There are basically three reasons for that. The first is it falls within the definition of a provable debt. If you look at, go again to section 139 of the Companies Law, behind divider 43,
Yep.
it's a very familiar provision again. It's the standard definition of provable debt, which has been there since the 1862 Act. Plainly, a claim to a redemption.
39.
Sorry, section 139(1), it's behind divider 43, page 1882. It's the normal, very wide definition of provable debt that one has seen throughout the Companies Acts. And plainly, a claim to a redemption amount which is accrued before the company has gone into liquidation is a provable debt. Second point is the effect of section 49G is not in our submission to render the debt not provable. That's not what section 49G says. If you go back to page 1876 of the same tab. Now, in our submission, what section 49G does is to subordinate the debt in right of payment. So in other words, you can prove for it, but in terms of an entitlement to payment from the assets, you're subordinated to the non-shareholder creditors. And then the third point is that there is some authority on this point, again in the form of the Compagnia de Electricidad case, back at Authorities Bundle 1, tab 14. And just so your lordships have the facts of this case, because it does arise in relation to a number of the issues, it was basically a position where a company had been carrying on an electricity business in Buenos Aires, was then nationalised, and the company went into liquidation in 1975. And because the capital history of the company had been so complicated, at the time it went into liquidation, there were various outstanding debts owed to former shareholders in respect of return of capital and unpaid dividends. And basically that was because the company hadn't been able to track down its former shareholders. So all these sums were outstanding. And one of the issues for the judge was whether these people were creditors in relation to their return of capital and dividends. Because if they were creditors, the court could then in effect set a bar date by which they had to prove. And if they didn't prove, they could be excluded. And the court held that they were creditors. And if you go to 174 A to B. You'll see the judge concluded there between A and B that the members and former members who owed money by the company were creditors. And as I say, the claims in that case were for unpaid dividends and unpaid return of capital. And if you then just go down, you'll see just below C, Mr. Justice Slade referred to a couple of cases over in Gurney and W.J. Hall, and then between E to F, perhaps just you pick it up against D, he refers to section 202(1)G, and then between E and F, he comes to the conclusion that the claims are nevertheless admissible for proof. So his view in that case was that the claims to unpaid return of capital and dividends were subordinated by 202(1)G, in other words 49G, but they were nevertheless provable within the meaning of section 316. And that's section 316 of the 1948 Act, which is in exactly the same terms to section 139 of the Cayman Companies Law. So we submit that that analysis is correct. If it matters, our claim is provable, but deferred in right of payment to all the outside creditors. Now, the effect
in the same terms as which section of the Cayman Law?
139.
Oh, it's 9.1, yes.
Yes, which is the definition of provable, provable debt. And the other point, perhaps just to note whilst we're there, is if you just go back to 173A to D on the preceding page. He deals there with section 302 of the 1948 Act, which is the same as section 140 of the Cayman Companies Law. And you'll see one of the points he makes is that, and this is really by letter C, is that liabilities there must include sums due to former members in respect of dividends or otherwise due to them in their character as former members, which is what one would expect, but he expressly confirms that liabilities within section 140 includes those type of claims. Now, the effect of this in our submission is to leave an entirely straightforward and logical waterfall. First, non-shareholder or outside creditors are paid in full. They get first go. Secondly, redemption creditors are paid after non-shareholder creditors. And then thirdly, the existing members receive a return of capital from any remaining surplus. Now, that's the conclusion which the Court of Appeal reached in this case. It's also the conclusion which the Court of Appeal of the Eastern Caribbean Supreme Court reached in the Monarch Point case, which I will come to. It also appears to have been the premise in strategic turnaround that would be the position. If I can just invite your Lordships to turn again to strategic turnaround.
Yep.
And it's paragraph 42, page 1117.
Yep.
As your Lordships know, strategic turnaround was basically concerned with the question of whether the deeming investor had standing to present a winding up petition. And essentially that turned in the most part on the provisions of the articles. Paragraph 42, there was a separate point which was run, basically to say that since the redemption creditor was subordinated to outside creditors, he didn't have standing because he only ranked after the outside creditors, and that was rejected by the board. But if your Lordships just look at the final sentence of paragraph 42, it was clearly the understanding of probably everyone concerned in that case. The waterfall was ordinary creditors, redemption creditors, and then members. Now, I'm obviously not suggesting your lordships have in any way decided the point, but one of the things we do need to do is to stand back and test whether the position we're arguing for makes logical sense. And it's clear that this order of priority didn't strike any of the parties or the Privy Council in that case as being in any way odd. Now, I think the only other piece of the jigsaw I then need to deal with is where section 37.7 fits into this, and in particular, the priority of someone who has successfully established a claim under section 37.7. Like, where do they fit in to the waterfall we've discussing?
Can I just ask you a question?
Yes.
Which of the cases you've referred to, I think it may be Consolidated Goldfields, deals most clearly with the position not of a debt which has arisen during membership, like a dividend or a profit, but of a debt or a liability which arises as a result of the termination of membership? It's really Consolidated Goldfields. I mean, I just wondered.
I think probably Compañía de Electricidad, because they deal with it there. He expressly deals with a return of capital as well as dividends.
Yes, I see.
And if your lordship go...
Oh, sorry, that was the case I was thinking.
Yes,
yes,
thought it might be.
not
If your lordships go...
Goldfields is extremely peripheral. It's a sort of incidental reference.
Yes, exactly. It's
no, it's this one. You're quite right.
Yes, and I mean, it may be quite helpful if you pick it up, first of all, on page 152, in the argument of Mr. Sykes for the liquidator.
Sorry, which page?
It's, sorry, tab 14.
Electronic tat, yes.
Tab 14.
Yes, Compañía de Electricidad, Buenos Aires. And if you pick it up, it's page 152,
yes,
just above E. I mean, he basically makes a concession that it must include returns of capital.
Where's that?
Just by page 152, just above letter E.
Well, is it concession? It's he's for the liquidators, isn't he?
So he says, section 2121G, the words or otherwise must, it is conceded, include payments made on a reduction of capital.
Yes, I see.
And then that's also picked up by the judge, who agrees at 170D. $170D. He says, by way of dividend profits or others, which the phrase must include some due to him by way of repayment of capital. And it does respectfully seem to us that must be right, applying the Soden test, because a debt which is by way of repayment to capital is something which by its very nature arises under the statutory contract. So we would respectfully agree with that. So I was just going to then deal with, if you like, the final piece of the puzzle on the waterfall, which is how you fit section 37.7 into this. Could I deal with that by asking your lordships to look at our written case at paragraphs 39 to 43, it's behind divider 9 of the core bundle.
39 to 43, yep.
Yes. Just a point on terminology. A redemption creditor is someone who we say has an accrued claim to a redemption amount as at the commencement of the liquidation. It's someone pre-liquidation who is already a creditor of the redemption amount. Someone who comes within section 37.7 is someone who is a shareholder at the start of the liquidation, but who is able to convert himself into a creditor by using the section 37.7 machinery. That's the point I'm going to come to and develop a little. And we say in paragraph 40, it would be logical to expect the redemption creditor to rank ahead of the 37.7 creditor because he's already got an accrued claim to the unpaid redemption amount as at the commencement of the liquidation. And we say that is also the effect of the provisions of the company's law. And that is really explained in paragraph 41. Subparagraph 1, claims of redemption creditors rank behind outside creditors pursuant to 49G. And then 37.7B1 effectively subordinates section 37 creditors both behind non-shareholder creditors and the claims of former shareholders. And you come to that conclusion once you read member in 37.7B1 in its normal sense as defined in the company's law.
Yeah, I mean, that was the leap that I was having some difficulty with. I
Yes.
still have some difficulty with, to be honest with you.
Yes, so it really, in our submission, there's nothing more to it than you simply apply the normal definition, which is in the following provision. And that does, we would suggest, I mean, the other way to test it.
Because, I mean, if you look at the Anglesey, the Court of Appeal case, which was followed in consolidated government
Yes.
laws, they seem to have thought it was obvious that member in this context of winding up included past member. They didn't go through this elaborate process that Mr. Justice Roxburgh went through.
Well,
Surely it does seem very odd to find practically the same term having a different meaning in two parts of the same act dealing with winding up.
Well, I'm not sure because I think the conclusion the Court of Appeal in Anglesey reached and the conclusion which Mr. Justice Roxburgh reached in Salford was very much in the context of what is now section 49. They were looking at the meaning of member in that context, and in particular looking at it throughout the subsections. And one can see, looking at how it's treated within those subsections, one is driven to the conclusion that in the specific context of G, having looked at A to F, it must bear the meaning of past member, notwithstanding the definition.
I mean, I understand how you put it.
Yeah.
You may be right. If you're wrong on that, where would it leave you under section 37.7B?
Well, it does then lead to an odd result, which is one of the
what I
reasons
thought.
we would say we're right, because if we're wrong about that, it would give rise to the potential for the 37.7 creditor to come above the redemption creditor.
Yeah.
But Mr. Justice Roxburgh's reasoning, which seems to have been followed without further analysis in later decisions, is simply, well, in some of these, I think it's current member and some past member, and they're all in the context of winding up, aren't they? I mean, he might have, it's not just pin-picking, but it's certainly open to, one would have thought, more expanded argument,
Yes.
which didn't seem to receive.
No.
His ultimate reason for thinking G was referring to past members seems to have been that E and F were,
Yes.
although A and P weren't.
Yes. I mean, I think the way he sort of approached it is that in the course of drafting the subsections, the draftsman had become slightly confused, if you like.
Past membership minded, yes.
Yes. And sort of they conflated the two. And then, by the way...
Anyway, it's said to be an exceptional provision. Why should we...
Well, it wasn't said by the Court of Appeal to be an exception. I mean, that's Mr. Justice Roxburgh's.
Yes.
Really trying to work it out for himself. But I mean, there's nothing very odd about saying that in the context of winding up, and given the sort of the framework of section 139 and 140, that the rights of members, qua members, should be subordinated to outside liabilities. I mean, whether they're past or actual. I mean,
Well, quite, and one can see why.
but I mean, I think that applies to section 37.7 as much as to section 49.
Well, I'm not sure it does, but in the sense that when you get to 37.7b, I mean, there's 2 points, if you like, we would rely on. One is the starting point must be the definition of member in the Act, and one asks oneself, why is it that one is departing from that to use a strained construction? And then the second is to ask yourself, well, does the outcome of that lead to a conclusion which makes any sense? And in our submission, applying member in its usual sense in the way I've suggested does lead to a logical outcome, as we explain in paragraph 42, because you have redemption creditors.
Yes, I mean, once you've sort of got over your first step, then I can see you can sort of work around it. But the significance of the point is it perhaps lends some support to Lord Goldsmith's submission that Section 37.7 is a complete code and that we should be dealing with gender with the enforcement of these member rights.
Yes.
Anyway, that's the argument.
Yes, I mean, I'm going to come to the purpose of Section 37.7 separately, but I mean, that's how we say the waterfall works, and there's no particular magic to it other than applying the normal definition of member in 37.7b1 as it's defined in the company's law itself, and indeed in the following section, Section 38. So, well, that was all I was going to say about the...
I mean, I come back to the point. It does seem to me, actually, that there is a potential distinction that might have been explored between redemption proceeds, which are the proceeds for giving up your shares and ceasing to be a member, and dividends, for example, and profits, which are inherent and arise inherently during your membership, but maybe there isn't.
Well, I mean, I see there's that distinction, but I think the way we've looked at it is to go back to the way the House of Lords analysed 49 Soda case and what they identified as, if you like, the litmus test, which is to ask oneself, does the right arise from or derive from the statutory contract of membership? I don't know if your Lordship would like to look at Soda.
Well, what page is that?
It's quite helpful on this point. It's in the Authorities Bundle 2.
26, yeah.
The relevant passages are really at page 323.
Wait, what about numbering of the bundle?
Sorry, 1667. So 1667, 323, between F and G, he defines, first of all, what he calls the statutory contract, which is basically the statutory contract created by the memorandum and the articles, together with the relevant provisions of the Companies Act. And then the conclusion is really on the following page between B and C. The principle is not members come last. A member having a cause of action independent of the statutory contract is in no worse a position than any other creditor. The relevant principle is that the rights of members as members come last, i.e. rights founded on the statutory contract are as the price of limited liability subordinated to the rights of creditors based on other legal causes of action. The rationale of the section is to ensure that the rights of members as such do not compete with the rights of the general body of creditors. And then one is asking oneself, is the right to an unpaid redemption amount a right founded on the statutory contract? Well, in our submission, it is, because it's a right that arises under the...
And the different wording of 37.7, you say we should, reading in context, confine to those who are remaining members, because it's dealing with the final stage of the winding up.
Yes, and that is how member is defined in section 38.
I see.
And also that leads to a result which we would say makes sense and is logical and coherent. So those are our submissions on the scheme and how all that...
49, I suppose, was drafted knowing what had been said about 49G or its equivalent in English law.
That's right. It was certainly enacted in that context. I mean, it's in basically the same terms as Section 38.7 of the 1862 Act.
Exactly.
But it was enacted in that context.
It had been, well, at least had been, on more than one occasion, had been interpreted as having the meaning which you contend.
Yes. So, as I say, that's what we'd say about the statutory scheme, how it all fits together, and it leads to the result we've outlined in paragraph 39 and following of our case. Now, that then brings us to section 37.7, which is the provision relied on, obviously, by the appellant in support of his arguments on this appeal. Our overall submission on this is that Section 37.7 is a red herring so far as Primeo and the other December redeemers are concerned. And the reason is because it has no application to a person who has already ceased to be a shareholder by the time of the commencement of the liquidation of the relevant company. And if we could just look at Section 37,
Yeah.
the relevant provisions, back in Authorities Bundle 2.
Yeah, page 1870. Yep.
Thank you. Well, I was going to start with I was just going to just look at the other subsections quickly as well.
We want to start at page 1867.
1867. So subsection 1, you've already seen, my friend Lord Goldsmith took you to that earlier. A company may issue shares which are to be redeemed or are liable to be redeemed. And that caters for two possibilities. Either the company can issue shares which are to be redeemed on a fixed date because they're issued with a date on which they will be redeemed, or shares that can be redeemed pursuant to some sort of process which is carried out under the articles. Now, Section 37, subsection 3, in our submission is important. Paragraph C, redemption or purchase of shares may be effected in such manner and upon such terms as may be authorised by or pursuant to the company's articles of association. And clearly the terms of any redemption or purchase will deal with matters such as when does the former shareholder cease to be a shareholder, or if it's a purchase, when the title to the shares pass from the shareholder to the company. But it's not in our submission right to say that's purely a matter of mechanics or procedure, that the terms of the repurchase or the redemption are likely to be very important and will tell you when the relevant person has ceased to be a shareholder. And we do say it follows from that, if you need to work out at what point in time shares have been redeemed, the normal way you would do that is to look at the terms of the purchase or redemption, which will be provided for by the articles or pursuant to the articles. Now, the other important provision in subsection 3 is paragraph G over the page. Now, you can ignore the word subject to section 37A for the moment, but it says shares redeemed or purchased under this section. And in our submission, that must be looking back to a redemption that takes place in accordance with C. Shall be treated as cancelled on redemption or purchase, and the amount of the company's issued share capital shall be diminished by the nominal value of those shares accordingly. So that, in our submission, is an important provision because under the company's law, the shares are treated as cancelled on redemption, which takes place in accordance with the terms of redemption as set out in the articles. So you look at the terms of the articles, ask yourself when redemption takes place in accordance with those terms, and then G provides that the shares will be cancelled on that redemption. So that's important because you then get to subsection 7, page 1870.
Yeah.
And there's a number of important clues within subsection 7 as to what it is concerned with in our submission. Firstly, it's dealing with shares which have not been redeemed. And in our submission, the logical meaning, or to give logical meaning to this, is to treat redeemed as having the same meaning in all the different subsections. So logically, that would mean shares that haven't been redeemed in accordance with section 37(3). And then, importantly, your lordships will see, just before the provisos, they shall be treated as cancelled. Now, that's very important because it shows that Section 37.7 applies only to shares which have not already been cancelled in our submission. Because it's saying that if you come within the section, we will and successfully invoke it, we will treat the shares as having been cancelled. But obviously, if you've already been redeemed under Section 37.3, then your shares will already have been cancelled under Section 37.3G. And in our submission, this demonstrates that the appellant's construction must be wrong, and that if shares have been redeemed and therefore cancelled for the purposes of Section 37.3, then they won't fall within Section 37.7. Section 37.7 only applies to shares which have not already been cancelled and therefore applies to shares which have not been redeemed for the purposes of Section 37.3. And really, what the appellant can't really do in our submission is to somehow drive a wedge between 37.3 and 37.7 and say redeemed means one thing in 37.7 and a different thing in 37.3. In our submission, it's all a coherent code, it's effectively seamless. You read it all together, and putting 37.3 and 37.7 together makes perfect sense. If you've been redeemed under 37.3, you're cancelled, you're therefore not within 37.7. Section 37.7 is looking at something else. It's looking at someone who is still a shareholder and who is therefore looking to invoke Section 37.7 to get the remedy conferred by that section. Now, some other important points on 37.7, just on the language. The operative part of the provision is basically providing a permission to enforce the terms of the redemption or purchase. That's what it basically allows or provides for. It says the terms of redemption or purchase may be enforced. The operative wording is may be enforced. And basically in our submission, it's permitting something to happen which would otherwise not be permitted. It's conferring a permission. It's saying if you come within the section, you can enforce. And what we say it's doing is providing a remedy for a shareholder who has an accrued right against the company for the purchase or redemption of his shares, but where the redemption or purchase has not been effected at the time when the company goes into liquidation. So someone who's got a right against the company to be redeemed, a contractual right, but who hasn't yet been redeemed because the company hasn't performed the procedure required to carry out the redemption or for some such other reason. Now, as a matter of general law, absent Section 37.7, such an executory contract would not normally be enforceable against a company in liquidation. And there's two reasons for that. One is the general proposition that you can't normally enforce a contract against a company in liquidation which requires the company to pay out money in order to acquire property. And we've referred to that in our written case as Reed Dynamics Corporation. Mr. Justice Oliver Holloway and York explained that it would be contrary to the pari passu scheme. So that's the first reason you normally can't do it. The second reason is that the company's law in any case says that once a winding up is commenced, a person can't change their status from shareholder to creditor without the permission of the court. And that's Section 99 and Section 125. And again, that makes sense because once winding up started, the shutters come down. So why is it someone should be able to go from being a shareholder to a creditor and thereby improve their position?
That explains the first proviso.
Yes, exactly.
If it was going to be, if completion was to be after the winding up,
yes,
then that would be caught by that principle.
Exactly. That's exactly right. So what it's doing is, in effect, providing a statutory exception to those principles, a permission. And it's basically saying to someone who has an uncompleted contract for the purchase or redemption of shares that you can enforce that contract exceptionally against the company in liquidation, you can exceptionally change from being a creditor, from a shareholder to a creditor, notwithstanding that the liquidation has commenced. But the
If
quid...
it ought to have happened before the liquidation commenced.
Absolutely, yes, absolutely.
501, yeah.
Absolutely. But it's subject to satisfying the conditions, and it's subject to the quid pro quo that, pursuant to Section 37(7)(b), you rank with that particular priority.
Dirty.
And the crucial point for present purposes is all this is concerned with a situation where the shares have not been cancelled or transferred to the company at the time of commencement of the liquidation. It's concerned with a situation where the company hasn't yet fulfilled its side of the bargain to carry out that part of the process. And it follows from that, this has no application at all to someone who's already ceased to be a shareholder and has become a creditor prior to the commencement of the liquidation. Such a person has already become a creditor. He doesn't need permission to enforce his claim against the company. He can lodge a proof. And as a creditor holding a money claim, he's simply entitled to make his claim in the liquidation in the normal way. And in our submission, that's perfectly sensible meaning to 37(7). It fits, moreover, with the context of the other provisions of Section 37, including in particular Section 37(3). Now, I then just wanted to address very briefly the ordinary meaning of redeemed. I appreciate your lordships are in the position of both sides saying redeemed has an ordinary meaning in ways which are diametrically opposed to each other. In our submission, the answers to the issues on this appeal turn primarily on understanding the statutory scheme and understanding the scheme and purpose of Section 37. But we also say our construction of the section is at least consistent with the ordinary meaning of redeemed in the context of shares in companies. Now, for these purposes, it's important, we respectfully submit for your lordships to have in mind what a share is. As we explained in that case, it's a bundle of rights in a company, typically the right to income, the right to a share of assets on the winding up, sometimes the right to vote as well. And it's been held that that bundle of rights together basically confer a proprietary interest in the company, although not in its assets.
Yeah.
Against that background, the ordinary meaning of redeemed in relation to a shareholder is when he has ceased to hold those bundle of rights, when he's ceased to have any interest in the company, and where his previous proprietary interest in the company has been replaced by a different right, such as the right as a creditor to a redemption amount on a winding up. And we say a share can be said to be redeemed where that interest in the company has effectively been removed or extinguished. He no longer has the rights as shareholder, he no longer has that proprietary interest, and he no longer has the status of shareholder. The other way to look at it, which we respectfully submit amounts to pretty much the same thing, is to treat redemption of a share as being synonymous with the question of when does a person cease to be a shareholder. In our submission, those are two sides of the same coin, basically. And you can test it that way. Well, when does a person cease to hold the capacity as a shareholder? That's the moment at which he's redeemed.
Yep.
And in our submission, that's the way the Privy Council looked at it in strategic turnaround, at paragraph 16, tab 5 of the authorities bundle. Page 1109. It's the top of page 1109, where Lord Mance is essentially summarising the issue in that case. The issue is not to be approached on the basis of any a priori view that until payment of redemption proceeds, a shareholder must or should necessarily remain a member of a company. And the way the Privy Council, in my submission, looked at it in that case, we would say rightly, is to regard redemption as being synonymous with the question of when does a person cease to be a shareholder. And we suggest that is its ordinary and natural meaning in the context of shares. Looking at cases dealing with redemption of bonds and mortgages don't exist, debt obligations are clearly very different. What you're concerned with here is a proprietary interest in a company and the question of when that ceases to exist. So we then turn to the particular grounds on which we rely in support of our proposition that Section 37.7 doesn't apply to the December redeemers. There's two broad points, essentially, which we've set out in Sections G and H of our case. The first reason which we deal with in Section G is simply that Section 37.7 doesn't have any application to persons who've already ceased to be shareholders by the time the liquidation has commenced. I've already covered most of the ground in relation to that.
We look at redemption, 37.7 deals with redemption and purchase.
Yes, it does.
What do you say would happen if there was agreement to purchase and the company bought its shares and then bought the shares, and then there was an arrangement whereby it would complete the purchase in the sense that it would acquire them, but that the money would still be paid, part of the purchase price would be paid later? Would it be the same thing, or would you say that?
Well, I think the question on your Lordship's example would be to identify whether or not title to the shares had passed to the
That's
company.
the essential point, is it?
Yes.
The title has passed.
Yes, in relation to a contract.
Have I purchased them if I still owe money for them? I've acquired them, but have I purchased them?
Well, it would depend on the terms of the contract,
no,
potentially.
Have I completed the purchase?
Well, it would depend on the terms of the contract.
You say the vital point on both redemption and purchase is title passing.
Yes, and the way to test it is to look at the position against the company in liquidation and ask yourself, against the liquidator, do I have a claim for a money amount, or do I have to get an order for specific performance of my contract against the liquidator? That's quite a useful way to test it.
I understand that. I'm just wondering about the language.
I mean, the essence of sale or purchase, as opposed to agreement or sale of purchase, is the passing of property.
Yes.
That's your
Passing of property in return for a promise of the price.
Yes.
And whether the promise is fulfilled is another matter.
Exactly. And
If none of the money is paid and the title passes, I've purchased it.
yes. I mean, that's effectively our position in this case, in the
Yeah.
sense that we've been redeemed, so we've lost our shares.
quite, I understand.
But the price hasn't been paid. But we say, well, we have a claim as a creditor for that in the liquidation.
Can I just try, I'm sure you're coming to it, and if you are, want to leave it. In relation to the argument that Proviso 1 doesn't fulfill any
Yes.
purpose, if you had, for example, a fixed redemption date, but unlike the present articles, the articles provided that redemption shall take place on the fixed redemption date, provided that the price is paid by the company
Yes.
on that date.
Yes.
Then surely you would have a situation where there was an agreement. The shares were to be redeemed, or were liable to be. They were to be redeemed.
Yes.
But if the company failed to pay the price on the date,
Yes.
they wouldn't be redeemed because it had failed. But nonetheless, the terms of redemption would provide for the redemption to take place before the winding up commenced, and that could be enforced under Section 37 after the commencement of the winding up.
Exactly. No, we entirely agree. And one can think of other examples as well. I mean, I suppose it's a slight variation on that example, but if one had shares which were redeemable in 5 years' time, but under the articles, the directors had to do something like pass a resolution or perform a calculation or something, but they didn't. One's in the same position, that the shareholder has the right to redeem, but the company effectively hasn't fulfilled its side of the bargain. I mean, that was really going to be my next point, actually, just to sort of sweep up on why we say Section 37(7) doesn't apply. I mean, the point that's made against us is the point my Lord Bantz has just been dealing with, which is effectively to say, well, our construction doesn't give it any utility, doesn't give it any purpose, and therefore it must be wrong. We've clearly just been discussing one example where it applies. We gave another example, paragraph 85, subparagraph 3 of our written case. And I think actually it's probably just the example I've been putting forward. It's page 940 of the bundle, tab 9.
Paragraph?
85, subparagraph 3. Internal page 34. So the example we give there is the shareholder lodges a valid redemption request, which is accepted by the company. So he has an accrued right to redeem, but redemption doesn't take place because under the terms of the articles, the directors have to do something. They don't do it prior to the commencement of the winding up. He's someone who's within 37(7)(a), and he wouldn't be disapplied by the first proviso because he had a right to redeem before the winding up commenced. And I suppose one can also make the point that Mr. Rabinowitz's clients may be a further example of someone to whom 37(7)(a) would apply in the sense that they had a right, they would say, to be redeemed, which accrued before the winding up started. And if he's right in his submissions, then that's an example of someone else who falls within 37(7)(a) and gives that utility.
Is that subject to the suspension point?
That's subject to the suspension point. So that example depends on he being right about the suspension point. But if he is right about that, he's someone else who is a good example of who Section 37(7)(a) would apply on our construction.
Does the same point apply to your example of the right which is subject to a step taken by the directors? Because arguably that right hasn't arisen if the directors haven't done the necessary step.
Well, no. I mean, all of this obviously depends on the terms of the particular articles in any given case. But what we were positing was a situation where the redemption request goes in, is accepted, and under the terms of the articles, that gives rise to an accrued right to have your shares redeemed at that point. And then, as a matter of procedure, however, internal procedure within the company, some step has to be taken to affect the redemption. So, I mean, that's what it has in mind. And one of the problems potentially is that obviously we look at this case sometimes through the spectacles of the particular articles of association we're concerned with here. But I mean, clearly this is a section that is dealing with a huge range of articles, and conceptually there's no real limit as to how they might be drafted. Now, the second reason why we say Section 37(7) has no application to Primeo and the other December redeemers is simply that there is no provision in Section 37(7) which has the effect of achieving the result for which the appellant contends, namely that our claims to our unpaid redemption amounts are subordinated. So as to rank,
H, is it?
this is Section H, yes, your Lordship's right. There's simply no provision that provides for the subordination, which my learned friend argues for. Now, it's very important in our submission to have in mind that the appellant's case, in effect, involves 3 stages or propositions. The first stage is to say that the claims of the December redeemers to the unpaid redemption amounts fall within the umbrella of 37(7)(a). That's their first stage. Their second stage is to say, however, we can't rely on 37(7)(a) because it's disapplied by the first proviso. So effectively they say we're in, but then we're out because the first proviso stops us relying on it. And then the third stage is to say that in those circumstances, the claims of the December redeemers to unpaid redemption amounts are subordinated to rank after all other liabilities of the company and only alongside the rights of existing shareholders to a return of capital. Now, the critical problem with that, there's simply no part of Section 37.7 which provides for that third stage and which achieves that result. I mean, there's simply no language within it that achieves that. There's nothing in Section 37.7 which says that a claim to a redemption amount which doesn't satisfy the requirements of the first proviso is relegated to rank alongside equity. And indeed, the point goes further than that, because the express provisions of the Companies Law, which we do have, in fact provide for the contrary result. Firstly, Section 141, which requires all liabilities to be paid before shareholders receive anything by way of return of capital. And secondly, Section 49G, which only defers the payment of liabilities owed to present and former shareholders to the claims of third-party creditors, but doesn't otherwise subordinate payment of those liabilities. So really the point is no more than asking yourself, well, what is the provision in the Companies Law which achieves the result for which my learned friend is contending? And the answer is it doesn't exist. And in fact, the provisions point in the opposite direction. And this point is in effect another symptom resulting from the fact that the appellant is seeking to apply Section 37.7 to a situation it was never intended to apply to. And that's because Section 37.7 isn't concerned with relegating the claim of a redemption creditor, so it only ranks alongside equity. It's looking at matters entirely the other way round. It's dealing with someone who is a shareholder and who already is equity. It's talking about pushing them up the waterfall. It's not talking about pushing anyone down. It's saying you might be a shareholder, you might rank at the very bottom, but if you satisfy 37.7, you get pushed up. As explained 37.7, it's not dealing with someone who's at the other way, who is a creditor, and saying, well, you're going to be pushed down. And as I said, there's simply no language that achieves that result. Some additional points we'd make very briefly in support of our position. Commercial uncertainty, in our submission, the appellant's approach would be contrary to reasonable expectations of investors and would cause commercial uncertainty. So far as reasonable expectations of investors are concerned, we do submit that an investor who read these articles might be forgiven for thinking his shareholder would be redeemed on the redemption day, and that he would from that moment have a creditor claim against Herald as creditor for the redemption proceeds. And that's what the articles say expressly. But if my learned friend Lord Goldsmith's right, the articles would be misleading in that respect, because the shareholder wouldn't be out on the redemption
It's all a
day.
bit circular, isn't it? I mean, it all depends on how you read the articles reasonably.
It's all a question of what they mean, which is what
Well, except there's no real dispute as to what the articles mean in this case.
Well, all right, yes. But then perhaps shareholders ought to know the law.
it ultimately depends on what the statute says.
Well, except that, I mean, if a shareholder's reading the articles, in my submission, he would think on the redemption day, I'm out as a shareholder and I've got a redemption claim. And that's the effect of our construction of the statute. If my learned friend's right, it's effectively a conditional exit, because he's always at risk of being dragged back in if the company doesn't pay the proceeds and gets goes into liquidation. And the Privy Council in strategic turnaround, for what it's worth, made a similar point in that case when looking at the construction of the articles there. We probably don't need to turn it up. I'll just give you the reference. It's paragraph 29.
Where is it, just to remind me, somewhere it was in the offering memorandum, there was the 20-day period.
Yes.
What do the articles say about payment?
It's as soon as reasonably practicable, I
Where do you
think.
find that?
Yes, and then let me find that for you. It's your lordship's right. The 20 days you find in the offering memorandum. It's
I mean, it's a sort of practical concession, isn't it, the 20 days?
Yes, it's, if you go to 826 of core bundle, tab 7, it's Article 22, sub-article 1.
Yeah.
And within that, as soon as reasonably
yes,
practical,
reasonably,
after
yes.
the later of the date,
Yeah.
the redemption of purchase takes effect. And then, as you say, that's then effectively expanded on in the offering memorandum.
Yeah.
Now, there's a couple of odd results which would also arise if my learned friend's approach was correct. Obviously, if he's right, a former shareholder who has redeemed his shares and is owed an unpaid redemption amount may be relegated in the event the company goes into liquidation to rank only alongside the remaining shareholders to a return of capital. So he's positing a situation, someone may be redeemed under the articles, but when the winding up happens, he may be relegated. Now, what would happen, one asks, if in that intervening period the company had declared a dividend, a huge dividend of all its distributable profits in favour of the existing members? So you would have had a redemption day 1. Day 2, company declares a huge dividend, pays out all its distributable profits to its members. Day 3 goes into liquidation. Now, if he's right, the entitlement of the existing members to that unpaid dividend ranks ahead of the shareholder who's been redeemed on day 1, and that, we'd suggest, is an extremely odd outcome. Why is it that matters should be looked at in that way? I mean, it'd be very odd, we suggest, for a claim of a former shareholder to an unpaid redemption amount to rank behind the claims of existing shareholders to an unpaid dividend, which is subsequently declared. So that's one oddity. The other oddity is to ask oneself how my learned friend's approach works in relation to different methods of returning capital. Because all we've been discussing today is are redeemable shares. But obviously, there's various ways in which a company can return capital to its members. One example would be the sort of examples that were being considered in Campania de Electricidad, where return of capital was made pursuant to a scheme of arrangement, say. Now, there's no suggestion that those sort of claims would be subordinated to rank alongside the rights of remaining shareholders to a return of capital. If you have an example, the company does a scheme, under the scheme it's liable to return capital to shareholders. It doesn't in fact make the payment, but then it goes into liquidation. I don't think anyone is suggesting that the shareholder who is owed that unpaid return of capital is subordinated to rank alongside equity. So in fact, what my learned friend's approach involves is effectively singling out a return of capital by way of redemption shares and subjecting that to a different regime, which wouldn't apply to other returns of capital. Well, I was then just going to show you very briefly the BVI case of Summers.
Could you just
Yes.
get that example? Return of capital under a scheme of arrangement.
Yes.
Company defaults on payment, goes into liquidation. No one suggests the shareholder owed a return of capital is subordinated to the status of an
Shareholder.
an ordinary member.
Yeah. So,
Yes.
whereas my learned friend says that's the case with someone whose shares are redeemed, but the redemption amount isn't paid. I mean, his approach effectively involves giving a very specific, and we would say odd treatment to a return of capital.
What is the status of a shareholder? It's a Section 49G
Yes,
situation
exactly.
there. Yeah.
Exactly. And that was basically one of the set of examples Mr. Justice Slade was looking at in the Campania de Electricidad case, because some of the claims in that case were returns of capital under schemes of arrangement which had taken place historically. So it does lead to a very odd treatment for return of capital by way of redeemable or repurchased shares. I was then just going to show you briefly the Summers against Monarch Point case, which is the BVI Court of Appeal decision, which there's been
This is
some...
the one which they overturned Ms. Justice Bannister.
Yes.
Yep. Is it a similar provision? Well, we'll see. Where do we find it?
It's Authorities Bundle 2, tab 27.
Thank you.
Now, it doesn't the BVI law doesn't have an equivalent to section 37.7, so it doesn't assist on that point, but it does have an equivalent to section 49G. So it does help on that point. And
I see.
if I can just invite your lordships to turn it up behind divider 27.
Very well.
Might just be worth looking at the head note first of all on page 1672. And you'll see there what it basically concerned before redeemed shareholders who had not been paid and the fund had gone into liquidation.
Yes.
And then over the page, top of the page, the trial judge, who was Mr. Justice Bannister, had held that as a matter of law that the claims of the redeemed members and of the continuing members should rank equally. And then that was basically overturned by the Court of Appeal, allowing the appeal. A redeemed member is a creditor in respect of his unpaid redemption payment.
Yes.
And then section 197 we'll come to. It's basically the equivalent of section 49G.
Yes. Oh.
And then 3.
Except it refers to redemption proceeds, but otherwise it's the same, yes.
Yes, it explicitly refers to redemption proceeds.
Enough.
I mean, to some extent, all we're doing here is, if we're with you, we say this is right, and if we're against you, we say this is wrong, right?
Probably right, yes. That's probably right. I mean, it is quite helpful, just to see how the Court of Appeal in a similar jurisdiction to Cayman, which does a lot of investment.
But as you say, it hasn't got section 37.
No, it doesn't. It doesn't deal with that point.
Exactly.
And just to give your lordship...
On your case, it makes no difference because it's irrelevant.
Yes.
Yeah.
Paragraph 12, you can see there, section 197 is set out.
Yes, yes.
And as my lord said, it does specifically refer to redemption proceeds there. And then section 207, paragraph 13 is effectively equivalent to section 140,
yes,
the Cayman law. And then really paragraph 20,
yes.
They make clear that a redeemed member is a creditor in respect of his redemption payment, and then just picking it up,
Yes.
make the point that he's deferred by reason of section 197, but nowhere in the Act does it provide that redeemed members should rank equally alongside continuing members by virtue of any adjustment or any other provision. Any adjustment must give higher priority to former members who've become creditors as a result of redemption than to mere continuing members. And then he basically then just elaborates on that point in paragraphs 21 and 22, explaining they're deferred, but once the outside creditors have been paid, they come ahead as members.
Yeah.
Now, the final point for me to deal with is our alternative argument, which concerns the first proviso. Because as I explained to your lordship, in order to succeed against us, the appellant has to establish both that section 37.7 applies to Primeo's claims, and those are the other December redeemers, and that section 37.7 is disapplied by the first proviso. Those are, if you like, the first and second stages of his argument.
So now standing effectively on your head in relation to the first argument, you're accepting section 37A applies, but saying the proviso doesn't.
Exactly.
This all turns on the suspension point.
Yes, exactly. Obviously this is very much an alternative argument because we say we're quite clearly right on the first argument. Now, just looking...
So which paragraph we got to in your case now?
we are probably very much towards the end. Section G, so paragraph 100 onwards. I should say, I think Mr. Rabinovitz is going to cover some of this ground as well, so I'll be relatively brief on this alternative argument.
Yep.
Just looking at the proviso, which your lordships will find back in the authorities bundle 2, behind divider 43, page 1870.
Yes.
So it's Roman numeral 1, provided that this paragraph shall not apply if the terms of redemption or purchase provided for the redemption or purchase to take place at a later date than the date of commencement of the winding up. So the question is, what date did the terms of the redemption provide for the redemption to take place on? Now, we're on my learned friend's case being right here, so we're assuming redemption does include payment. So we're in the alternative world where we're wrong. Now, just looking at how the first proviso operates in those circumstances, the redemption requests were received by Herald for a redemption day of the 1st of December 2008. Redemption proceeds were to be paid as soon as reasonably practicable thereafter, and under the offering memorandum, within 20 business days of the redemption day.
Yes.
And the Herald then went into liquidation on the 14th of February 2013. So quite clearly there's 20 business days between the redemption and the commencement of the liquidation. And it's quite helpful, we suggest perhaps, to look at the confirmation which was issued at the time, which your lordship will see in the record bundle behind divider 6D.
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 Yep. Page.
170.
Thank you. Yes, I see.
This is the confirmation of redemption that was issued by the administrator. I mean, it's obviously quite helpful for my primary case as well, in that it shows the redemption being conferred and the shareholding balance being reduced. But you will also see expected payment date. They put there 1st of December 2008. Now, in our submission, even if one accepts the appellant's case that redemption includes payment of the redemption amount, then on the face of it, the terms of redemption were plainly not such that the redemption was to take place at a date later than the date of commencement of the liquidation. And that's not the effect of either the articles or the offering memorandum. Clearly, payment was to take place at the latest within 20 business days of the redemption. Now, the appellant's response to that has been to seek to argue that the effect of the resolution passed by the directors of Herald on the 24th of December 2008, suspending the payment of the redemption proceeds, somehow modified the terms of the redemption, such that the redemption was then to take place at a date after the commencement of the winding up. And you'll find that resolution in the core bundle behind divider 14. It's 271. Actually, sorry, 1008, I think is the correct reference. 1011.
Behind divider 13. Yeah.
Yeah, so let's start with divider 13. So there were two resolutions. First of all, behind divider 13,
Yeah, we got that.
on the 12th of December to suspend calculation of the NAV and the issue, redemption and conversion of the shares. And then there's a second resolution behind divider 14, 12 days later on the 24th.
Circular resolution.
Yes, and you'll see it's really paragraph 6. The directors consider that their initial resolution to effect the suspension is fully effective, but wish to clarify, for the avoidance of any doubt, that the suspension applies equally to the payment of redemption proceeds. Now, as we understand it, the point that's put is to say, well, that suspension, in effect, modified the terms of the redemption, so that the payment thereafter only became due after the commencement of the winding up. Now, we say that's wrong, because if you look at Article 22.1 of the Articles of Association, which I think we can pick up in the statement of pick up in the statement of facts, core bundle divider 7, page 826.
Yep,
And it's,
826.
yes, it's the bottom of that page. In all cases, the directors may suspend the payment of redemption proceeds in circumstances where the valuation of the net assets of the company or of a separate class has been suspended pursuant to Article 19. So the power, we suggest, is a power to suspend payment.
Yes.
And the effect of that is not to modify the terms of the contract, but to suspend performance of the terms. The existing terms remain unaltered, not least because the suspension can be lifted. And there is no power under the terms of the articles to modify the redemption.
Isn't this slightly metaphysical? The amount is payable as soon as reasonably practicable. If you suspend payment, aren't you extending the period within which it has to be paid?
You are extending the period in which it has to be paid.
But isn't that, but, I mean, the term of payment is payment as soon as reasonably practicable. If you suspend that to payment next year or whenever, isn't that an extension of the term of payment?
Well, in our submission, the starting point is to look at the language of 37.7a1, which talks about what do the terms of the redemption provide for. Now, in our submission, the redemption is in effect a contract between the redeemer and the company, constituted by the Articles of Association. So effectively, it's a contractual
They not
relation.
suspended it because it was impracticable to pay.
Well, the question is whether the terms of the contract have been modified or varied in our submission.
I see.
And we would respectfully suggest there's a difference between a power to suspend performance of terms that remain unaltered and a power to vary or modify those terms. And if it had been expected that the terms could be varied or modified, you'd expect to see an express provision to that effect. So that's all I was going to say on our alternative argument. I've addressed you, obviously, at some length on our primary argument. Subject to any questions your lordships have, those are our submissions.
And you're going to come back after we've heard from the two interveners, is that right?
Yes, I reserve the right to do so, if I may.
Thank you very much, Mr. Smith. Thank you. Mr. Rabinovich, I think you're on next. If you want
With
to...
your shift, my lord.
Again.
That's the...
My lords, until now, your lordships have been addressed by my learned friends on the question of whether, as my learned friend Mr. Smith says, Section 37.7 is a red herring.
Yes.
And he says, of course, he's not in Section 37.7, leave aside his alternative case. Lord Goldsmith also says he's not within Section 37.7. Now, that is not a fight that we're involved in. As between Lord Goldsmith and Mr. Smith, our position is neutral. Our position is different. We accept that we have not been redeemed. However, we submit that by virtue of having exercised the option to redeem, which the articles give, we are entitled to enforce the terms of redemption in accordance with the provisions of Section 37.7. My lords, our position therefore is narrow. What I have to satisfy your lordships about is first that we are within the broad ambit of Section 37.7a, and secondly, that my clients are not ejected from the application of Section 37.7 by the first proviso. For the purposes of this, I shall take your lordship to, again, section 37.7, which you've seen a number of times, just to make some limited points, and also to the articles. But before I take your lordships to that, can I just remind your lordships of the position of Reichmuth, as I'm told it's pronounced, and the late Redeemers. As your lordships will have picked up, Reichmuth and the late Redeemers sent redemption requests on the 12th of December 2008, but they sent in those requests before the resolution of that day, which suspended the calculation of the net asset value of the shares in Herald. And so this timing puts the late Redeemers' requests between the December Redeemers, who sent their redemption requests before the 1st of December 2008, and the later Redeemers, who sent their redemption request, that's Natixis, who sent their redemption request after the resolution of 12th of December 2008. And my lords, as your lordships know, our submission is that we are within section 37.7a and we're not ejected by the first proviso. Can I therefore develop those 2 points? Once I've done that, I do need to come on and mention fairly briefly the 3 subsidiary points that your lordships have seen in our written case, dealing with our position vis-à-vis the December Redeemers and the later Redeemers, the question of priority, and also the question of calculation of the NAV, which is a point I think raised by some of my learned friends. My lord, so far as concerns the first question, namely, are we within the broad ambit of section 37.7a to begin with? If your lordships just very briefly turn up section 37.7.
It's in your case, isn't it?
It is, and I should say this part is the point I'm developing now is between paragraphs 38 to 43. That's internal page 12 of my case. If I can invite your lordships just to go again to section 37.7, just to identify the first point that I'm dealing with. So it's in authorities.
That's what I meant was in your case.
I beg your pardon?
I mean, that is in your case in paragraph 2.
That is in our case, indeed. But if you don't want to look at it there, you want to look at it in the statute, Authorities Volume 2, tab 43, at page 1870.
Yep.
And just looking at subparagraph 7a, where a company is being wound up and at the commencement of the winding up, any of its shares which are or are liable to be redeemed have not been redeemed, the terms of redemption or purchase may be enforced against the company, and then we have proviso 2. So to come within the first part of section 37.7, I have to establish that my shares, or the shares of the late redeemers, are shares which are or are liable to be redeemed, and also that those shares have not been redeemed. My lord, so far as the have not been redeemed is concerned, it is common ground that the shares of the late redeemers and Reichmuth have not been redeemed. And so the only thing I would need to establish in order to come within section 37.7a is that the shares that the late redeemers held, the Herald shares, are shares which are or are liable to be redeemed in the first place. Now, starting off here, I had understood there was going to be an issue about this, because certainly reading the liquidators case, and in particular paragraph 65, there appeared to be a suggestion that one could only say that one's shares were liable to be redeemed if one had actually gone into the process sufficiently that you had an entitlement to payment, and there hadn't been payment. I can just show your lordship that I'm not pointing this out to say there have been any changes, but
Just to make it clear. Yep.
just to make it clear why I am dealing with this point.
Understand. So this is in Lord Goldsmith.
Lord Goldsmith, paragraph 65,
Thank you.
which your lordships will have at page,
Internal
internal page 25.
Yep.
And it's really this paragraph. It is submitted that the correct interpretation of section 37.7 is to interpret any of its shares which are liable to be redeemed have not been redeemed as referring to shares in respect of which the company's prospective contingent liability to pay redemption proceeds has arisen but not been discharged.
The date for payment has arisen and passed.
Exactly that. Now,
I mean, what possible reason can there be for saying that the date for payment
hasn't passed except the suspension argument.
In my case.
Yes.
Can I get to that?
At the moment, we're concerned with construction.
With construction?
Yes.
At the moment, I just want to establish that I'm within section 37.7 in the first place. I'll come to the suspension and the relevance.
Yes, but I mean,
At the moment, that's on the table, as it were.
That's on the
It
table.
wasn't- yes, okay,
And in my respect for submission, the contrary is unarguable.
right.
Once one looks at section 37.1 on
Proviso
page
1.
1867,
Proviso 1,
proviso, no, subparagraph.
subparagraph 1, I
The
do.
Lordships will recall subparagraph 1 of section 37 has the same
Oh,
phrase,
yes, yes.
which are to be redeemed or are liable to be redeemed.
Quite right, yes.
And that's plainly talking about the kinds of shares in issue, the kinds of shares that the kinds of redeemable shares which can be an issue. And effectively, I think as Lord Goldsmith identified, what one is talking about there are shares which have a mandatory date for redemption, or ones which give the shareholder, indeed the company, the option to redeem. And here, in the case of Herald, we're dealing with shares which have the option to be redeemed. That's to say they are liable to be redeemed.
well, yes, but they've got to be liable, or they've got to be or to be liable to be redeemed at the date of the commencement of the winding up. And as I understand what this paragraph 65 is suggesting, it is that since payment is inherent in the concept of redemption, if payment is suspended until the commencement of the winding up, so that there can't be redemption by payment, the shares can't be or be liable to be redeemed. Winding up, this is rather complex.
In my respectful submission, my Lord, all that section, the opening part of section 37.7 is doing is identifying that you're dealing with shares which are or are liable to be redeemed, in the sense they are shares which have that nature, and that they have not been redeemed. Now, the question of whether redemption for these purposes
I see.
depends upon Mr. Smith being right or Lord Goldsmith being right is irrelevant so far as my clients are concerned. In either event, my shares have not been redeemed, but they are still shares which are liable to be redeemed.
Even if you hadn't done anything?
Even if they hadn't, the later redeemer shares are shares which are liable to be redeemed.
I see.
And I think that is what Natixis says.
Yes, I see.
So in my respectful submission, we plainly come within the opening part of section 37.7.
An alternative is that something more is meant than just being redeemable shares, that something must have taken place which actually means that redemption will, other things being equal, occur.
That is, as I understood, what the liquidator was saying, and my submission about
He says quite a lot must take place, but
well, indeed,
it could be a certain amount.
But in my respectful submission, nothing needs to have taken place, because that would require that one give the language in section 37.7, where it talks about shares which are or are liable to be redeemed, a meaning which is different to the same language which appears in section 37.1.
So what you're saying is, in theory, even if you hadn't even exercised your right to do anything, they would still be within that category, but, of course, you'd be caught by little one.
Exactly.
If you tried to exercise your right to redeem after the winding up, because ex hypothesi the date for payment would be after winding up.
My Lord, with respect, yes.
Yes, I see.
So, in my respectful submission, that is why we are within section 37.7 in the first place. A more difficult question, and I think a more controversial question, is whether we are taken out of section 37.7 by the first proviso. And can I just address your Lordship on that? And the way I propose to deal with this, my Lords, is to take you to the articles and to identify what the articles of association actually say, and then to make the submission that, leaving the suspension to one side for the moment, if one does leave the suspension to one side, we are plainly not caught by the proviso. It will then be my submission that the suspension makes no difference.
On the face of it, little one is saying you've got to have been converted from being a shareholder or member into a creditor by the date of winding up.
In my respectful submission, that, with respect, is not correct.
I was going to say,
In my respectful submission, as my learned friend Mr. Smith has already submitted, what subparagraph 1 is doing is to say that if you have an accrued right to redemption prior to the commencement of the winding up, then you're entitled to enforce the terms of redemption. And if your accrued right to redemption has not arisen at the commencement of winding up, then you don't.
now when you say an accrued right, the words like accrued can be slightly slippery. Do you mean you've got a right at that date, but the right to be paid may be after that date? Or not?
Indeed.
So you must have exercised the option.
Precisely. That is
So
my case.
That's the point. You must have exercised the option, not that you must have the right to be paid.
Exactly. And because once
The present right to be paid, yeah.
not the present right to be paid. If I've exercised the option so as to effectively put the company under an obligation to redeem, and I've exercised that option prior to the commencement of the winding up, then in our respectful submission, what Section 37.7 does, including subparagraph 1, is to give that party, that shareholder, the ability to enforce the terms of redemption. And in my respectful submission, there is nothing in the articles to suggest that one gets to a...
Wait a minute, it's not little one to do, if you're going to give redemption the same meaning as redeem, isn't it directed not anything to do with payment, but to do with what's happened to the shares? The redemption to take place at a date.
It's the terms of redemption provided for a redemption to take place. In other words, one has to look at the terms of redemption and say, what did they provide? My submission is going to be, my lords, that one looks, one can test this. I'm going to jump ahead, but since I've only got 45 minutes, I don't mind doing this. If one tests this by reference to a share which carries a mandatory date for redemption, and one says, having regard to a share which has a mandatory date for redemption, let's assume the mandatory date for redemption is a date prior to the date of the commencement of winding up. Where that share has a mandatory date for redemption, then that plainly, and the date for redemption is prior to the date of commencement of the winding up, then in my respectful submission, the way Section 37.7 works is to enable that shareholder to enforce the terms of that redemption, whatever the company may do, in whatever way the company may avoid or prevent that redemption taking effect. And in my respectful submission, the position is no different where one, rather than having a mandatory date for redemption, has shares which are liable to be redeemed, but the party exercises his option to redeem. Because as soon as, in this case, a shareholder exercises his option to redeem, he is given a date for redemption. Yes. And if that date for redemption falls on the right side of the commencement of the winding up, he has the right to enforce the terms of the redemption.
Well, isn't that really why A is confined actually to situations where the option has been exercised?
Indeed.
Because otherwise it doesn't make sense to talk about the terms of redemption or purchase unless there's either a fixed date for redemption or an option has been exercised.
That is what one is concerned with.
I get. Well,
and that, in short, is our position.
Yeah. So
now,
say once it's been exercised, then
it doesn't matter what happens next.
As long as it falls due for performance, completion of redemption before the date of the commencement of the winding up, fine. And then you've got the problem. The only problem remaining in your way is the suspension argument.
Well, the question is whether the suspension does anything to change that, because once you've exercised the option, you are given a date for redemption. Now, it may be that the company can suspend performance of that and say, well, we're not going to perform that. But the whole purpose of this provision is to say, well, that's all very well. You may have exercised your right to suspend and therefore not performed, and indeed you haven't performed, and we're at the commencement date. But this is a provision which gives us the ability to enforce the terms of redemption.
You've still got proviso 2 to get over.
We still have proviso 2 to get over, and that's a very important proviso. And I don't know the facts of this, and it may be that after this we go back to the Justice Jones in Cayman, and he says, forget it. There's just not enough money to pay you.
I think it's important when one construing two, one, not to try and
Absolutely.
push too much into
Absolutely,
it,
because
which is the proper province of two.
my Lord is entirely right, and because one doesn't have to be concerned about one, because two is there to look after the company and indeed the creditors of the company. Now, that may, my Lords, be a convenient moment. I'm very happy to carry on. I was going to take you next to the articles, and I'm happy to start that. But
I think probably, I think for good case management, which is now all rage, I would want to be satisfied that we'll finish by 1 o'clock tomorrow if we break now.
Your Lordships have given me 45 minutes. I think I've had 15, or I may have had less. I would be confident, but I can only speak for myself, that I will not exceed my time.
Been quite helpful to look at the articles. Let's go on for a few minutes.
Very happy to do that. Can I then just invite your Lordship, I think for the first time, to go to the articles which are in the record at 6B.
Let me have a look.
The relevant parts of the articles begin at page 85.
Thank you. Right. Friendly looking page, right.
Now, just point out, this isn't actually part of the terms of redemption, if one wants to call that. Article 19 at the top of the page gives the directors the ability to declare a temporary suspension or determination of the price of the participating non-voting shares. That was obviously relevant in this case. But so far as the provisions relating to redemption are concerned, they start at Article 20, and they go, and I'm going to take you through and give you an overview of this, until Article 23. So starting at 85 and going to 88. And my Lord, just by way of an overview, Article 20, subparagraph 1,
Yes.
identifies the fact that the shares, the participating non-voting shares carry an option to redeem. In other words, the shareholder has the right to
Right.
redeem.
These are liable to
Indeed.
redemption. Okay.
And so that establishes...
That's all we need from 21.
Plus, what it identifies is that the redemption will be for an amount equal to the net asset value. So it identifies the right to redeem, and it tells you at what value that's going to be redeemed. And one sees the second part of that beginning about 4 lines from the end of that.
I'm sorry, Mr. Rabinowitz, one of us has a commitment I was
sorry.
unaware of. No, you shouldn't apologise. I should. I was unaware of it. Let's adjourn now. I'm sorry. And
My Lord,
we'll
what-
resume
if-
it.
I can go through the overview, my Lord.
Sorry?
Lord, I can get through the overview in 2 minutes and then get into the detail tomorrow.
Right, well, just tell us the paragraphs.
So Article 20, subparagraph 1 gives you the right to redeem, and it identifies the value at which the redemption is going to take
Okay.
place. Article 20, subparagraph 2
Yep.
does 2 things. First, if you look 6 lines from the end, it says it identifies the date when the redemption will take place.
Right.
The redemption and purchase will take effect on the redemption date. And secondly, it tells you when the net asset value per share is going to be calculated. That's to say, at the valuation point
Okay.
relating to that redemption date.
Immediately prior, yeah.
Yep.
Subparagraph 3
Yep.
identifies the fact that once you have exercised your
You
option
can't
to
pull it
redeem,
back.
you can't go back.
Right.
Subject to Article 20, subparagraph 4,
Yes, absolutely.
which says where there's been a suspension, one of the
Okay.
things you can do is to go back.
Okay.
I'll have to come back and develop 24 before, again. If you go to Article 21 over the page, I'm sorry to race through this.
Yes.
Article 21, in contrast to Article 20, is dealing with a situation where the company wants to redeem.
Understand.
And again, the redemption for the company is going to be on the redemption day.
Yep.
Article 22
Yep.
is dealing with the payment in respect of any
Yes.
redemption. And also, if you look at the end part of Article 22, you can see that the directors have the ability to suspend
Yes.
payment of the proceeds. And then Article 23, my learned friends have already taken you through.
That's
it talks
right.
about the consequences of redemption. That's to say removal of the shareholder. That was all I was going to say by way of an overview. Tomorrow I'm going to come back to Article 20, subparagraph 2.
Very well. Thank you very much. Thank you, Mr. Rabinowitz. We'll resume again at 10:30. Court's now adjourned. Thank you.